Hello everyone, and welcome to another Eltoma webinar. My name is Georgia, and I will be talking with you about the strike-off and the liquidation procedures. I will be describing and illustrating some special aspects of the procedures. Generally speaking, it is accepted that a company shall not be left abandoned, irrespective of whether there is where it is incorporated or whether, therefore, where a company must close. There are two options available. First one, the company can be struck off or a company can be liquidated. Whereas both procedures result in the cease of the company, the points to be considered at each procedure is substantially different. For the purposes of our discussion, of our presentation, our focus will be on how the above procedures are applied. This is for companies incorporated in Cyprus, in Singapore, and other 3 tax haven jurisdictions. These are Seychelles, Belize, and British Virgin Islands, or referred to as BVI. So, the key points to consider in our presentation today, it's the procedure for strike-off for Cyprus companies, for Singapore companies, and for the 3 tax haven jurisdictions. We'll move on to the liquidation procedure for Cyprus companies, Singapore companies, and again tax haven, the 3 tax haven jurisdictions. And finally, we will consider the role of directors, the risk they bear in Cyprus companies and the duties in Singapore companies. All right, to start off, the strike-off procedure in Cyprus is a primarily simple method in which the Register of Companies in Cyprus takes action to be notified and finally dissolve the company. The criteria in order for the procedure to be successful are the following. First one, the financial statements of the company must be prepared until the date of the strike-off. The company must be deregistered for VAT and obtain a tax clearance certificate for that purpose. And then on, there will be a submission to the registrar of a formal letter application signed by a director requesting the company to be removed from the register of companies, and this will include a statement that the company has no liabilities. And above filing such letter, the registrar will examine the application, and if satisfied, the company that the company is indeed does not carry out any businesses or it's not operating, the registrar will publish a notice to the official gazette with a view to strike the name of the company of the registrar. And after 3 months from the date of the notice, the company will be struck off the register and then be dissolved. So again, the procedure is the 2 letters verifying the carrying of the business activities, publishing, and the 3rd letter, and the failure to submit the annual return. So, So whenever the Register of Companies has any reasonable grounds to believe that the company does not carry any activities, it is entitled to send 2 letters to the said company. And this is in order to verify that the situation is that the company is not carrying any activities. So if the recipient fails to reply to the 2nd letter within 1 month, the registrar will publish the said company in the official gazette in order for the company to be struck off. And if the registrar does not receive any reply, again, it will proceed with the publishing, and it will send a letter to the said company stating that in 3 months from the receipt of the letter, the company will strike off unless there is a reason for the contrary. From the 27th of May 2004, note that the registrar has made it clear that the failure to submit the annual return will result in the deregistration of the company from the register in accordance with Article 327 of the Companies Act. Also, as from September 19th, 2014, the registrar will send notifications to all companies that they not annual returns. This matter will be discussed next. So, HE32, it is the annual return. It has to be submitted once a year by every Cyprus company, accompanying it with the audited financial statements of the said company. This must be 15 days after the AGM, the annual general meeting of the company, and within a time limit of 28 days from the date of its issuance, it must be submitted. Simply said, it must be completed and filed with the Register of Companies within a time limit of 42 days from the annual general meeting of the company, and within 15 months from the previous annual return. This is without regarding the calendar year. Kindly note that here that the AGM of the company must be held within 18 months of the date of the incorporation. The next point is the payment of the annual levy. So it is equally important to be considered because an amount of €350 must be paid by every Cyprus company no later than the 13th of June of each relevant year. The law states in this matter that in a case a company delays to pay the levy, but proceeds with the payment within 2 months from the date due, the penalty to be imposed will be 10%. And if it proceeds within 5 months from the date due, an additional penalty of 30% will be imposed. If a company, though, does not comply with its obligations to pay the levy within 5 months from the date due, the registrar can remove its name from the register and deny the filing of the documents or stop processing requests from the issue of certificates by the registry without any notification. However, the company may be restrained automatically, and the registrar will proceed with the correction of it in its records in case the company within the period of 2 years from the strike of the amount of €500 is paid, or after the expiration of the 2 years from the strike of the amount of €750 is paid. Final point, it is to be said that the restoration of a company which has been struck off can occur following an application. This is before the expiration of 20 years from the publication in the official gazette of the notice for the strike-off. Simply said, the court must be satisfied that the company was at the time of the striking off carrying out business, and therefore it may order that the company is restored to the registrar and the company shall be deemed to have continuous existence as if its name has never been struck off. An application on this purpose can be made by a company or any member or director of that company suffering by the company having been struck off the register. Final thoughts. Considering the above, the procedure in Cyprus companies is fairly simple to understand and apply. Usually used by companies that have ceased their trading activities, have no assets, no obligations, and do not intend to carry out business in the future. And this is usually referred as dormant companies. The normal procedure will follow the decision of the court, as been discussed. The failure to submit annual returns, pay annual levies, and whether the registrar has reasonable grounds to believe that the said company does not carry out any activities can lead to a company to be struck off. This is the general thoughts on the strike off for Cyprus companies. Next on, in respect of Singaporean companies, the responsible body is ACRA. This is the Accounting and Corporate Regulatory Authority, the acronyms for this authority. Simply, a company can apply for the strike off its name under Section 344 of the Companies Act in Singapore, and ACRA may approve the application. Again, if there is reasonable grounds to believe that the company is not carrying on activities, businesses, and the following requirements should be met. So the company must have ceased trading, must not be involved in any court proceedings, whether inside or outside Singapore, must have no assets and liabilities at the time of the making of the application. The company, again, must not have any outstanding penalties or offers of composition owing to the registry. The company must not have any outstanding tax liabilities with IRAS. The company must not be indebted to other governmental departments. The officers of the company must have an outstanding ACRA summons against any of them. It must be clear for any outstanding summons from ACRA. The particulars of the directors must be the same as in the records of ACRA, sent to the striking off, and the company must obtain a letter for this consent from each individual shareholder. The application for the strike off of Singaporean companies can be made from a company director, the corporate secretary, or professional firm online via the BIS file in order to be successful. Depending on the complexity of the case, the application may be processed within 7 working days, and together with the application and declaration of strike-off and tax clearance and a waiver of forms, if necessary, should be accompanying the application. And this is a process which can take up to 6 months, 5 to 6 months to be fully completed. So once ACRA approves the application, it will send a striking off letter to the company's register office address, its officers at their to the officers at their residential address, and also to IRAS. Anytime after 1 month from that, there is no objection, and if there is no objection, ACRA will publish the name of the company in the Governmental Gazette, and this is widely known as the first Gazette notification. Following 3 months period from the first Gazette notification, if there is no objection, ACRA will publish the name of the company in the Government Gazette again, and the name of the company will be struck off the register. The date that the company is struck off will be stated, and this is known as the final Gazette notification. The entire process again can take up to 5 to 6 months. Any person interested, it's important to know that it can lodge an objection against the company via BIS file again. If the interested person suspects that the company intends to apply for striking off, he may lodge a notice of intention to lodge objection to future striking off application. And this notification will be valid for 1 year. During the 1 year period, if the company submits an application for striking off, ACRA will notify the objection via email. To object to a striking off application, any interested persons can submit a lodgement of an objection against striking off. So ACRA will then withhold the striking off and send a letter informing the company to clear the outstanding matter within 2 months from the date of the objection. If the company is able to resolve the matters within 2 months period, the objector is required to lodge a clearance of an objection to striking off via BIS file again before ACRA can proceed with the striking off the application. And final point to consider is that if a company is unable to solve the matter within 2 months period, the striking off application will lapse and revert to life. The company will have to submit a fresh striking off application, and if it still wishes to be struck off from the register. A company also can write to ACRA to apply for a withdrawal of the application for striking off at least 5 working days before the company is scheduled to be struck off the register. The reasons for withdrawal should be clearly stated in the letter addressed to the ACRA. After the company has been struck off, it can be restored within 6 years, for the date of striking off. A court order is required in order to restore a struck off company, and upon receiving the court order, the notification of restoration of company that has been struck off or dissolved via BIS file must be filed for this purpose. Moving on, IRA, as mentioned before, is the Inland Revenue Authority of Singapore. The Inland Revenue Authority, IRAS, has the ability to object to a strike-off application. In order to avoid an IRAS objection, the company must ensure that it does not have any outstanding tax liabilities by doing the following things. It has to submit all outstanding income tax returns, all accounts and tax computations up to the date of business cessation, ensure there is no outstanding tax matters, and cancel goods and services tax registration, while ensuring there is no outstanding GCT, good and services tax matters. If the company never commenced business, or if the company hasn't engaged in any business since filing its last income tax return, then instead of filing an income tax return, it can file an application for a waiver of income tax return submission by a dormant company, and this will be along with a cover letter stating its intention to apply for strike-off. Final thoughts on the strike-off procedure for Singaporean companies. It's fairly easy to understand that it's a strike-off procedure for a company registered in Singapore. The relevant department authority will be ACRA. A relevant application must be made there, and several criteria discussed before will have to be met and finally obtain an approval from ACRA. Once a company is closed down, an application, in addition to ACRA, it's important to notify the Central Provident Fund Board, the Inland Revenue Authority of Singapore, and finally the relevant licensing authorities for this strike-off. Moving on, we'll be considering three tax haven jurisdictions. This is Seychelles, British Virgin Islands, BVI, referred to as BVI, and Belize. So to start out, unlike Cyprus and Singapore, it has to be noted that in tax haven jurisdictions discussed below, the company struck off automatically when the respective company fails to pay its annual renewal fee. The deadline for annual renewal fee for each tax haven jurisdiction varies. However, all jurisdictions has also penalties if the license is not paid in due time. So even though a company is struck off, any liabilities that lies are still pending for the company in question. So in respect of BVI, British Virgin Islands companies, this is the penalties for that when they're not met for annual renewal fee. If the deadlines are not met, the company can be automatically struck off. So for the first half of the year, this is incorporated between January and June. The license to be paid is due on the 31st of May. A 10% penalty is applied when between 1st of June and 31st of July. A 50% from 1st of August until 31st of October. And the strike-off will occur on the 1st of November. For the second half of the year, that's companies incorporated between July and December, the license due is the 13th of November. 10% penalty occurs for failing to pay within the period of 1st of December to the 31st of January, and then 50% penalty for 1st of January until 13th of April. And the strike-off for this will occur in 1st of May. The restoration period for this BVI company strike-off, it's within 7 years. Next on, for Seychelles companies, for the first half of the year, this is companies incorporated between January and June. The license due is the working day before the date of incorporation, and there's a 10% penalty on the date of incorporation if the renewal fee is not paid. 50% for 90 days after the due date, and the company will be struck off the 21st of December of the same year. When the company is incorporated and shareholders incorporated between July and December, the license due is a working day again before the date of incorporation. 10% is applied on the date of incorporation for failure to pay renewal fee, and 50% 90 days after the due date. Company, in case of failing to pay renewal fee, will struck off on the 31st of December of the following year. The restoration period for these the shareholders companies is within 3 years. And finally, the table illustrates the percentages from Belize companies. This is more straightforward. All annual license fees are due on the second day of January each year. If a company fails to pay the annual license fee by the 31st of July, there is an increase of 50%. If the company fails to pay the annual license fee by 31st of December, the company will be struck off the register. And the restoration is, again, as is shareholders, it is 3 years. So we had discussed about the strike-off procedure. We're moving on into discussing the liquidation procedure. By definition, in finance and economics, liquidation is a process where a company comes to an end and is distributing its assets to claimants. It is usually occurred when a company is declared insolvent, which subsequently means that it cannot pay its obligations when they come due. So therefore, once a company's operations end, the remaining assets are used to pay creditors and shareholders. And this is done by considering the priority of their claims. So having said that, generally speaking, there are two types of liquidation, and this is a compulsory winding up or the voluntary winding up. And although the procedures to be followed are very much the same in Singapore and Cyprus companies, our discussion will focus on each of these areas separately. To start off, the liquidation procedure in Cyprus companies is discussed under Section 203 of the Chapter 113 of Cyprus Companies Act, and mentions that there are two methods of liquidation. This is a compulsory winding up compulsory winding up by court, and the voluntary winding up either by the company itself or by its creditors. So, the compulsory winding up of a Cyprus company. Section 211 of Chapter 113 covers the area. And generally speaking, the most common ground for compulsory winding up is where a company is unable to pay its debts, and either the company, a creditor, or the official receiver can file a petition on this purpose. Subsequently, the court may appoint a liquidator to wind up the affairs of the company, and where there is no liquidator appointed by a court, the official receiver will be appointed as the liquidator of the company. The powers and the duties of the liquidator basically include the filing of all necessary notifications required under the Companies Act, and are discussed below. So, when said that someone is unable to pay its debts, under Cyprus law and Chapter 130, Article 212, a creditor whose claim has matured and remains unsettled can apply for the district court for an order that the company should be liquidated. A key provision of the law is that the company is unable to pay its debts, and this is when, if a creditor of an amount over 5,000 euros has served the company by delivering to its register office with a notice claim signed by the creditor or his advocates, which demands the payment of the amount owed, and for the following 3 weeks of the company does not settle or reach an agreement with the creditor in relation to the debt, or if an execution or other proceedings undertaken by virtue of an order by the court is returned partly or completely unsatisfied, or finally, if it is proven to the satisfaction of the court that the company is unable to settle its debts. And to determine this, the court will take in consideration the future and potential obligations of the company. So, Having discussed when a company is unable to pay its debts, it has to be considered we have to consider the powers of the liquidator. So once a winding up order is made by court, a liquidator will be appointed by the court and will be responsible for the administration, control, and property of the company. And this is by virtue of section 233 of the chapter 113, and the following powers are granted to the liquidator. The liquidator can sell a company property and things in action by public action or private contract. It can sign on behalf of the company any receipt and other documents for that purpose to use. It can use the company seal. It can prove a debt or to claim against the state of the bankruptcy. Can submit a person to perform anything that he cannot perform, and do all things necessary for the winding up of the company and the distribution of the assets. Also, it can bring or defend any action or other procedure in the name or on behalf of the company. He can carry out the company's business so far as may be necessary for the beneficial winding up of the company. It can appoint a solicitor to assist with the performance of his duties, can pay any class of creditors in full, and can compromise with creditors. Finally, once a liquidation of a company's assets is fulfilled and every matter is settled in accordance with the powers granted to the liquidator, a petition for the final wind up of the company is filed by the liquidator to the court, it is at its absolute discretion whether it will issue an order for the final dissolution. And this is according to section 216 of chapter 113. The next point, it's voluntary winding up of a company. A company can be put into liquidation voluntarily under the attention of its directors. A member's voluntary winding up happens when a company is solvent, and in particular when the directors believe that the company is in a position to pay its full debts and liabilities within 12 months after the commencement of the winding up. This is totally opposite of the matter we discussed before. This obligation is by making a declaration of the solvency in the form of an affidavit. The company then will appoint a liquidator to wind up its affairs and file the necessary notification required under the Companies Act. The effect in either case is that the liquidator is appointed to bring the company's existence to an end so that it can be dissolved eventually. The catalyst of the members' voluntary liquidation is a decision by the directors that the company has no further purpose and that available assets should be realized and distributed to the shareholders. In the absence of a declaration of solvency by the directors of a company, it may be decided to move on with the creditors' voluntary winding up. And here, directors believe that it cannot bear its liabilities. The company cannot continue its business. The company will then appoint again a liquidator or a provisional liquidator to wind up its affairs and file necessary notifications required under the Companies Act. So once the winding up commenced, for the time the petition is filed, any disposition of the company's property, including things in action and any transfer of shares or alteration in the status of members of the company made after the winding up commenced, should be void unless the court states otherwise. Any proceedings against the companies are automatically implemented or cannot commence after the winding up order except with leave granted by court, and on such terms it may be opposed. The employment contracts or agency agreements come to an end in respect of the company. The directors are dismissed of their powers to act on behalf of the company, and the liquidator takes into custody and control all company's property and things in action of the company. The company may be disclosed voluntarily by its own owners or by an order of the court under certain circumstances. Under company law in Singapore, it is a duty of the directors to wind up an insolvent company, again, a company that cannot pay its debts as they fail due. A director, a creditor, may go to the court and apply for a judgment to be registered against the company in relation to the debt. And if they are still unsuccessful in receiving their payment, another option is that a creditor may apply to the court and have a company wound up if that company is insolvent. So this is in respect of companies in Singapore. And generally speaking, there are different reasons for closing company in Singapore, which is pretty much the same as for companies liquidated in Cyprus. Well, the company should have ceased business activities or is not profitable, cannot pay its debts and it's insolvent, it's irrecoverable and dispute among shareholders in place, the corporate and financial restructuring of the group at which the company belongs, the company is dormant and the owners does not want to incur ongoing compliance and maintenance costs, and there is a breach of statutory provisions, including offences being committed. So, a Singaporean company may decide to wind up its affairs voluntarily if the directors believe that the company will be able to pay its debts in full, and this should be done within 12 months after the commencement of the winding up. A majority of directors of the company must take a written declaration of solvency at a meeting of the directors, and once the declaration has been filed with the registrar, the director must send to the members a notice of an extraordinary general meeting. This will be convened for the purpose of passing a special resolution to wind up the company and an ordinary resolution to appoint the liquidators. The AGM, the extraordinary general meeting, shall be held within 5 months of the directors' meeting executing the solvency declaration. Consequently, with the calling of the meeting, the directors or partners are required or partners are required to appoint an approved liquidator to the provisional liquidator between the issuing of the declaration of solvency and the holding of the AGM. The notice of the appointment of the provisional liquidator and a copy of the statutory declaration must be advertised within 14 days of the appointment of the provisional liquidator in at least 4 local daily newspapers, and one should be published in English, Malay, Chinese, and Tamil languages, respectively. At the EGM, the voluntary wind up of the company needs to be resolved by way of a special resolution. That is by a majority of not less than 17% of the votes of the members entitled to vote. Furthermore, one or more natural persons who have been given their prior written consent must be appointed as liquidator or liquidators. And usually in Singapore, accountants are preferred for this position. And finally, a second special resolution has to be passed. This will give powers to the liquidators to divide all or any of the properties and assets of the company among their members. Within 7 days after the passing of the special resolution, a printed copy of the special resolution must be filed with ACRA, and this must be done within 10 days. A notice of the resolution must be given in 1 or more newspapers circulating generally throughout Singapore. The company must ensure that all documents issued by or on behalf of the company containing the company's name are amended to include the words "in liquidation" after its name, and hand over all company's books and records to the liquidator. So, with the passing of the special resolution at the EGM, the members voluntary liquidator of the company is deemed to have commenced. The liquidator or the provisional liquidator, depending, will proceed to wind up the affairs of the company and file the necessary notifications required under the Companies Act. The liquidator will also proceed to prepare and file the relevant notice and advertisement, including the settlement of creditors' claims. He attends to the company's income tax clearance, filing of the company's accounts, and as well as determining how much it is to be returned to the company's shareholders following the payment of the company's liabilities and debts. And as soon as the affairs of the company are fully wound up, the liquidator must draw up an account showing how the winding up has been conducted and how the property of the company has been disposed of. Then he will have to call a general meeting of the company for the purpose of presenting and explaining the account to the meeting. And the liquidator, within 7 days after the meeting, will launch with a grant and the official receiver a return stating that the meeting has been held and attach a copy of the account. Final point to consider is that on the expiration of 3 months after the lodging of the form with the registrar, the company will be dissolved. However, the court has the power to declare the dissolution of a company to be void at any time within 2 years after the date of dissolution. The application must be made by the liquidator or any other interested person. Going on to the area of creditors' voluntary winding up, it must be noted that a company may decide to go in this route if its directors believe that it cannot, by reason of its liabilities, the company cannot continue its business, and then the company will again appoint a liquidator or a provisional liquidator, and he will or she will wind up its affairs and file the necessary notifications to the required under the Companies Act. The procedure in this area, it's again the same. The same as discussed above. So the effects of voluntary winding up of a Singaporean company, it is that with effect from the date of passing of the special resolution, the company must cease to carry on its business, except insofar as it is required for the beneficial winding up in the opinion of the liquidator. The director's powers will cease, except where the shareholders, with the consent of the liquidator, have resolved that the directors should continue to have such powers. And finally, any transfer of shares is void unless made to or sanctioned by the liquidator, and the status of the members cannot be altered. So when a company may be wound up under an order of the court, this is happening at a certain circumstances. That is, in case the company is unable to pay its debts, or when the court it is in the opinion that it is otherwise just and equitable that the company is being liquidated. The company itself, its creditors, shareholders, the liquidator, or judicial manager may initiate liquidation proceedings with the High Court, and the court may appoint a liquidator to wind up the affairs of the company. Where no liquidator is appointed by the court, the official receiver shall be liquidator of the company. The company will normally cease upon liquidation. The liquidator will start to review the assets of the company and the claims of the creditors, and look into conduct of its directors and other related persons to realize how company's assets in a manner that it is for the best interest of the company and its creditors. The liquidator may also carry on the business if he considers it the most beneficial option. The officers of the company are generally deprived from their powers, and any other person who may have been concerned with the affairs of the company have the duty to assist and cooperate with the liquidator. And this includes the submission of the state of affairs of the company's assets and liabilities. Finally, after all assets of the company has been assessed and realized, the liquidator will adjudicate all the claims lodged against the company and admit or reject them accordingly. Any surplus after paying the creditors and cost of liquidation will be returned to the shareholder. Once compulsory winding up occurs, an application must be made to the court to stay or restrain pending proceedings against the company after the presentation of the wind up petition and before a winding up order has been made. After a wind up order has been made or a provisional liquidation has been appointed, a leave of court is needed to commence or proceed with action against the company. Any disposition of the property of the company and any transfer of shares or alteration of the status of the members of the company must, after the commencement of the winding up, the court is void. No creditor is allowed to take any out or continue attachment or execution proceedings against the company. The rights of the secure creditor to deal or realize its security over company assets are not affected if prior to the wind up of a company has been carried out with the intent of defending or defrauding the creditors of the company or any fraudulent purpose, the liquidator, creditor, or contributory of the company may apply to court to make the person who has been responsible for that or as party to such activities to be personally liable. Where there's a mutual credit steps or dealings between the company and the creditor, these where there's mutual credit debts this between the company and the creditor, these dealings may be set off, and there can be no claim for offset if at the time of the extending credit the creditor has known that the wind up pension was pending against the company. The liquidation becomes necessary for a client if he faces the possibility of future liquidation or liabilities surrounding the business operations. If the company preserves that the nature of the business is such as the future liquidation liability is unlikely, that they may simply choose to have the company's loss, but it is at no cost. And this is for tax haven jurisdictions. The company must pay its annual renewals if such becomes due, and before the registry will accept the liquidation. There should be preparation of some documents, the payment of annual renewal, and the submission at the registry. This is for the articles that should be submitted with the application. For beliefs and shareholders, it's articles of association, the plan of distribution of dissolution, minutes of the meetings of the board of directors, the declaration of IBC registry to liquidate, appointment of a liquidator, the statement of assets. And for BVI companies, the consent to act as a liquidator, the declaration of solvency, the notice of appointment, the plan of liquidation, the shareholders' dissolution, the board of dissolution, and the statement of assets and liabilities for the company. So the final part of our discussion is in respect of directors. Their duties of a director under companies law and other legislations, such as the income tax legislation, are not exclusively codified. They are a combination of statutory duties, common law practice, and the duties combined in every company's articles of association. So, in respect of Cyprus companies, directors may be liable for prosecution by the Inland Revenue of Customs and Excise in respect of tax-related offences. There's a fine, thin line between legitimate tax avoidance or mitigation and tax evasion. Both Inland Revenue and Customs Excise have the power to prosecute and bring criminal proceedings against individuals involved in tax evasion, either personally or through their companies. Typically, Inland Revenue will give the opportunity for the person to come clean and provide a full disclosure, and therefore a prosecution is unusual. So civil penalties are more common. In the Inland Revenue is much more inclined to bring criminal proceedings against a professional advisor. Next on, the Department of Inland Revenue and Department of Value Added Tax has been merged into a single tax department that states that the liabilities of directors in Cyprus companies, and this is under Article 51 A. The assessment and collection of taxes has been amended to render members of the board of directors of a legal entity criminally liable on their personal capacity for legal entities from mental or willful submission of tax returns. It's also extended to the entity's executives, like including the legal entity's chief executive officer or any other executive with responsibilities as to the financial management of the legal entity. And under the amendments, any person that omits or neglects to settle the tax withheld under the and for after mentioned is guilty of an offense. So an individual shall be liable for a monetary penalty of 5,000 euros and of 2 years of imprisonment, and a company shall be liable for monetary penalty of 5,000 euros, and their directors and other executives may be found liable and is subject to 20% of the tax dues and 2 years of imprisonment where the tax due exceeds 1,700 euros. For remaining taxes, such as example corporate income tax, an offence will be sustained only if the omission neglect is proven to be carried out fraudulently or willfully. In respect of Singapore companies, the duties of the directors is to keep proper accounting records, produce to the shareholders a profit and loss account and a balance sheet at least every once a year before the annual general meeting. Traveling of accounts, balance sheet, and credit directors report at the annual general meeting again, and call of an annual and extraordinary general meeting and convening of meetings. Also, they have to comply with the required procedures for reduction of share capital, ensure registration of changes, obtain approval of the company for the disposal of companies undertaking, ensuring registration of certain resolutions and agreements, preparing and launching of the annual return with ACRA, ensure that dividends are only paid out of profits, and appoint the first auditors. The taxpayers are required also to make payments within a month from the date of the notice of assessment that is received to pay the taxes, and when a payment is not made in due time, 5% penalty is imposed and 1% penalty for every month that tax remains unpaid. If tax is not paid, the taxpayers will have to deal with enforcement actions against IRAS, and the taxpayer will receive a demand note with an imposition of penalty, appointing banks associated with the company to pay taxes from the bank directly to IRAS. IRAS, it is entitled without any notice to the taxpayer take action to recover tax, such as the appointment of a bank employment tenant or lawyer as an agent to pay the funds owed, and or relevant restriction order, take a legal action against the company, and can issue a directive for forbid the taxpayer from direct traveling outside Singapore. The travel restriction will be lifted by IRAS once tax is paid up. So this was the whole presentation. Whereas the result is the same, when a company is struck off or when a company is liquidated, the company ceases to exist. The liquidation or winding up procedure is formal procedure with the appointment of a liquidator, whereas the strike off procedure is more easy, faster, and less costly for the company. Thank you for your interest and your attendance in this webinar. Some words about us. We are in the field since 2004, maintaining a competitive position in the corporate market. For over 10 years, our clients have been enjoying the range of products, giving them opportunities for solving international tax planning issues, asset protection, as well as promotion of goods and services for international markets. We offer solutions for varying complexities, from company registration, legal and tax assistance to establishing and maintaining composite holding structures. We have our offices in Cyprus, Singapore, Russia, Ukraine, and Hong Kong. We aim to provide our clients with a personal cost, effective and efficient services, which include company corporation and maintenance, bookkeeping and finance, bookkeeping and accounting services, tax planning, IT and web services, software business, web and marketing services, legal services, immigration services, license and permits. We expanded our services to custom equipment services to support employees within Cyprus market to select the best person in the correct position. You can visit our website, Eltoma Equipment, now offering all your recruitment needs, an ideal way to obtain access to our increasing local CV database, no fees charged without making successful placement, and HR consultancy services post-required placement. Due to the increasing importance of the CFS regulation for business-related purposes in Cyprus, we have identified and now we can help. We have expanded our services portfolio into property. We have a number of unique properties all over Cyprus for investment opportunities. And should you wish to find out more, any of the properties on screen, you can also visit our website, enter your email address in the chat box on the screen, and once our property agent will revert to you shortly. Or you can alternatively visit our website. Thank you very much for your attention. Any questions you may have, you can email me on my personal email on screen, and I will try to address and get back to you as soon as possible. Thank you once again for your attention, and have a nice day.